Hi, everybody. My name is Nathanael Player. I'm the director of the Self-Help Center in the Law Library at the Utah State Courts. My job is generally to provide and expand access to justice for the people of Utah. I do that by telling you what we got, helping you understand the law, and making sure people know how to access the court system. Have you heard of the Self-Help Center before? Do you know what that is? Raise your hand if yes. Uh-oh. Okay, well, that's bad. So if you haven't heard of the Self-Help Center, you should know about us. There's a business card that we have that looks like this. And it is a totally free, 100% no cost resource that you can use to get help. And so I'm old. And when I was not old, there was a TV show called Who Wants to Be a Millionaire? The way it worked is you have to answer questions. And if you didn't know, you could phone a friend. And that person would be on the phone to help you figure out what the answer is to your question. And the Self-Help Center is like phone a friend for any legal issue that you have, whatever it is. The card that I'm holding is in Spanish on one side and English on the other side because almost all of us are fluent in Spanish. We help directly in Spanish. We help in English. You can call, text, or email to get through to us. And I'm going to show you how to get in touch with us on the computer here. But we also have cards for people who are here that you can take back to your offices. So on the court's website, you can click Representing Yourself here. And you can click Need Legal Help. You could actually have done that from the home page. And one of the things that comes up here is the Self-Help Center. And the Self-Help Center's information is here. And the main thing you need to know is that if somebody needs help, it's a legal issue, and they aren't sure where to go, you should have them contact us, and we can help figure it out. The expectation is not for you all to leave today being experts in questions regarding evictions. The expectation is that you can understand how to triage some basic issues and that you can help people get connected with resources. But if it's something you don't feel comfortable with, you can have them call the Self-Help Center or text us or email us. So the Self-Help Center is virtual. It's not like it's only for people in Salt Lake and everybody else has to figure it out. The Self-Help Center is available to everybody everywhere in the state. If you're in Snowville, if you're in St. George, anywhere in between, the Self-Help Center is a free resource to help you. So you can email us at selfhelp@utcourts.gov. You can call us at 888-683-0009, or you can text us at 801-742-1898. For those of you who are familiar with the Self-Help Center, what's the #1 complaint about the Self-Help Center people have? Do you know? I'm going to air my dirty laundry. It's hard to get through. People don't call, and they get mad when they call because they can't get through. They can't get through because we're really popular, because it's amazing. It's a free resource. You can call and get help with any sort of legal question you have. So because of that, it's hard to get through. So calling is a good option for things that are hard, but it means you're going to have a hard time getting through. What I tell people is call later in the day and later in the week. Later in the day, it's easier to get through. Most people call us when we open at 11, and then it's busy over the lunch hour. But if it's around 4:30, you're more likely to get through. Also, Tuesday after a holiday, it's hard to get through. Thursday or Friday is a better day to get through. So you should know about the Self-Help Center before. And just to be clear, we can help in Spanish. We can also help in any other language. If you don't speak English or Spanish and you need help, we can get a court-certified interpreter, and we'll schedule an appointment to call you back to help you that way. And that is also free. So all of our services, the help and information we provide is free. We're also the ones who maintain all the resources on the court's website that I'm going to walk through in terms of how to help people. If you call us, the very first question we will ask is, how can I help? There's no screening. Don't care about your immigration status. Don't care about your income. We'll just help you. There's no getting through screening questions before you get help. And most people who call us will get a follow-up in the form of a text message or an email, depending on what their preference is, reiterating the main points of what we talked about and linking to some key information that would help them, like a web page or a form. So that's the Self-Help Center. What questions do you have about us and our ability to help people? Well, let me clarify. It's legal information. I'm a court employee, so I can't give advice. But I can give lots of custom, specific legal information tailored to your unique situation. Could be rent, could be somebody died. What do? I need to deal with this person's property because they died. It could be I got screwed over in a small claims case and I need to sue somebody. It could be I'm getting sued. I need to get divorced. I need custody. I need help with a protective order. Anything legal. That's why it's like, it's really powerful. Like, it's amazing. Any legal question at all, does not have to be housing.
Someone online asked who gives the legal advice when people call in, but like you said, it's not legal advice, correct?
So there are 5 staff attorneys who work at the Self-Help Center, and they are trained as lawyers. They have their bar licenses, but we're all court employees, so we can't give advice. I can give a different presentation about information versus advice, but the short answer is we're going to listen to people's questions, explain things, translate what they're saying into legalese, and translate the legalese into English for them so they can understand how to proceed. We're sort of like interpreters in that way. And then we will help them understand their options. So if somebody calls and says, I need to get divorced, we can help explain to them how to get divorced. That's not maybe the best use of our time because that's really easy to figure out, but we could do it, and we would, and we'd be happy to. Somebody could call and say, I've asked the court for more time to file an answer in my case. What happens now? We could explain where they're at. We could look at the case and see specifically what's going on and say, this is what happened. This is why the court has or hasn't responded. Here are the things you need to do. Here are options you have. That's the kind of thing we could do for, again, anything that's state law in nature. And if we can't help you, we'll refer to somebody who can. So there are things that we don't know about, like immigration. We're not going to be able to help with that necessarily, but we could refer to people who do. So we make it a point to know about all the legal resources in the state and refer people to those resources as they need them.
Someone online had a question. Can you set up appointments in advance to talk to someone?
Unfortunately, you can't. But emailing can be a good option if you're worried about getting through on the phone. We don't do appointments and we don't do callbacks. The reason why is because our model is based on Alaska's model, which has a similar self-help center. And the way Alaska worked is that they did do callbacks and appointments with people. And what they found when they tracked their time, that they were spending more time playing phone tag than they were actually providing help to people. So we didn't want to replicate that mistake. We learned from them. Just call, and if you can't get through, call again. Keep trying. So, and just to be clear, I go back to the court's homepage. Actually, it's not on this one. So how I found that before was I clicked representing yourself, and then I clicked need legal help here. And the first link was the Self-Help Center. So that's how you can find us. If you're in person, I brought you a bunch of cards, so you can take them. If you're online, just remember how to find us. And if you want me to present, you can get in touch with Cody on the chat, and I will present to you and bring cards to you.
Do we have a number?
Yeah.
Are texts responded to quickly, or how does that work?
Yeah, we usually respond to text really quickly. People got to go to the bathroom, people got to eat food, they got to take lunch breaks, but we do respond relatively quickly. Text is the fastest way to respond. So it's a little bit tricky, and I'll tell y'all this as service providers. Sometimes people just need a phone call, right? Because it's complicated, it's confusing, it's difficult, and they're sort of scattered and they're thinking maybe they have a hard time focusing. That kind of person might do better on a phone call. If somebody's really on top of it and they just need a quick answer, text can be a good option, right? But if they're really in depth into the minutia of their case, they've got a lot of subtleties, very specific things going on, that might not be a good text thing. Email is usually a good option because we can sort of format and we can add spacing to try and help people understand. If you're texting or you're emailing, we're going to send you some links because we have a web page that explains almost everything. We can have forms. And if you call, we're going to follow up with a text or email similarly to connect with those. Please know about the Self-Help Center. Refer people to us. We're glad to help. And I can do a more in-depth presentation if somebody wants and bring you cards like we're doing today. What I was asked to talk about with you all was eviction. And it sounds like that's a big concern people have, and that's something people need help with is somebody's getting evicted, what do I do? And so for those of you who are in person, you've all been served with a summons and complaint. I physically handed you the papers. I saw you all take them. So you've all been served with an eviction notice. And let's talk about that for a second. And for those of you online, I'm going to pull up the summons so you can see what it looks like. I got it. So for you online, this is what we're talking about. Looks like this. Looks like this. Looks like this. But let's pause for a second before we get into this. I wanted you all to get comfortable with the papers and play with the papers because I know that that's something people come to you with is, what do I do with these papers? So I want you to feel comfortable looking at them and understanding what the different papers are. But before we do that, I think we need to define some terms. So do people ever come to you and say, I'm getting evicted? Okay, what does that mean? In my mind, that could mean like 5 or 6 different things. Okay, so getting evicted could mean I've been served with some kind of paper. It could mean that the landlord is just being a jerk and threatening to evict me. What paper I've been served with could be a couple different ones. Getting evicted could mean that I'm actually, the sheriff's here right now physically removing me and I am literally getting evicted at this moment. The state, with the force of the sheriff's office, is dispossessing me from my home. That's what eviction ends up doing. So it could be anywhere along that timeline from there's something unhappy going on between me and my landlord to no, the force of the state is bearing down upon me. And there's a lot of stuff that can happen in between. And so part of what I'm hoping to equip you to do is to drill down and ask more questions and talk to people about where they're at when they say, I'm getting evicted, because what they should do at different points in time depends on where they're at in that process. Does that make sense? So let's look at the paper. So what do you see in front of you as the first paper that's there? A summons, yes. And this is the failure of my department as the person who's supposed to make it easy within the court. Was it easy for you to figure out what that form is called, what that document is, or did you have to look at it for a minute to figure it out? You had to look at it, right? So that's one of the things that I'm doing a bad job on, and I apologize. The name of the document is in the middle in this space here. You'll know it's the name of the document because it's bolded, but it's really hard to tell. We actually have a video on our website that explains how to read court papers, but I need you to just be able to tell your people, court papers, the name of it's here. If I were looking at it and I didn't have a law degree, I would look up here at this top left corner and think that's the name of the document because that's how we organize information in Western society. But that's not how we do it at the court. Hopefully one day we can fix that and the name of the document will be in the top left corner. Until now, you have to know that you read where the court information is, and then you read the plaintiff and defendant, and then you go over and see that the name of the document's here, okay? Okay, let me pull up one more thing while we're talking. Another thing that y'all should know about is this flow chart, which explains the eviction process. Let me walk through this, and then we'll come back to the papers. So there are 3 big steps that are bolded and gray on this flow chart. And the first is that the landlord serves a notice to vacate. The second is that the landlord files a summons and complaint. And then the third is the landlord gets that order of restitution. So that's what I'm thinking about when I'm thinking about, am I getting evicted? What's happening in my case? Does that make sense? So you all have in your paperwork a notice to vacate of some kind. It should be in there, and you all have different papers. Some of you have the same ones, but some of you have different ones because you're not all going to get the same thing when you're talking to people. So can somebody look in your paperwork and tell me what you're getting evicted for? It's in a notice. Yeah, Jenny. Pay or vacate. Has anybody heard of that before? Happens sometimes, once in a while. Anybody else have anything different than a 3-day notice to pay or vacate when you look at your papers? It's going to be underneath. Yeah. "30-day notice to vacate." Okay, so they're terminating your lease. Anything else? "30-day notice." You got the same one? Oh, shoot. Great. Okay. So, and I'll show you folks online what a notice looks like as we go through this. CARES Act 30-day notice. Great. Okay. So here's, for the people online, this is what a 3-day notice to pay or vacate looks like. And it means you have 3 days to pay the rent or move out. Another example is 3-day notice to comply with the lease or move out. So you have to fix whatever violation you have against your lease. Your lease says, do or don't do these things, and you're doing something you're not supposed to do, or you're not doing something you're supposed to do. So you might get a notice that looks like this. Another possibility is that you would get a notice for nuisance, and somebody in the room should have a nuisance notice. Dogs. That says you're causing a nuisance, and they have to explain what the nuisance is and why you're having the nuisance. So those are the kinds of things that people would get. And that would be step one of the process. So at that notice stage, what are people's options? What can they do? What's that? Pay or move out. That's about it. Or if it's about something other than that, they can figure out, solve the problem that's happening with that's described in the notice. So, yeah. So just to be clear, if it's a notice to pay or move out, pay or vacate, they have 3 business days. If it's any other kind of notice, it's 3 calendar days. Which isn't very much time at all, to your point. It's even less time, right? It's not very fixable, really. But at that point, so let's talk to you for a second. So if somebody comes in to one of these people's offices and they say, I'm getting evicted for non-payment, and they come to you, could you turn around a rental assistance check before the notice expires?
Not really. I mean, maybe under the perfect circumstances where all the stars align, but typically no. 3 days to get a payment for rent relief is pretty unheard of.
So what would you do instead if somebody's coming in with a 3-day notice to pay or vacate?
Reach out to the landlord to see how serious they are about that 3-day pay or vacate. I guess because I know that they legally need to issue that to protect themselves to be able to collect, is my understanding.
They have to issue a notice to be able to collect rent.
Even if they're going to work with you.
I mean, it used to be, but they have to issue the notice if they're going to proceed. Oh, I'm sorry, and I had myself on mute. The question for Cody was, do you feel like it's legal advice or representation to call up the landlord and try and talk to them about the notice?
But no, I guess my interpretation of legal advice is taking someone's scenario and applying it to, or using a law to apply it to that situation. So just communicating with the landlord would not be considered practicing law.
I don't get to make those determinations, but I think that lots of people do that, and I don't know that anybody's getting in trouble for that. So if you all felt like somebody's coming in with a notice, can I call the landlord? I think if you're going to call the landlord and try and negotiate and argue with them, that's a different thing than if you're saying, I just want to understand better what's going on here. I just ask them inquisitive questions, understand what's happening here. That would be probably well on the line of safety in terms of you're not going to cause problems. But that's, you know, if your client wants you to do that, right? Okay. Questions about the notice. To be clear, the notice is the start of the eviction process. So if somebody says I'm getting evicted, it could mean that they're thinking about getting a notice. The next step, if the tenant doesn't magically fix it within 3 short days is that the tenant will get served with a summons and complaint. And at that point, the tenant has two options. I mean, there's always a third to call the landlord and try and work it out. Is that going to work here? I don't know. But what the tenant can do is they can either ignore the summons and complaints and just disregard it. And if that happens, then the landlord within 3 days can get a default judgment, and that's a fast track to eviction. The other option is for the tenant to pay attention to it and maybe perhaps with your help, make a decision to file an answer in the case. The tenant files an answer, then the court will schedule an occupancy hearing. This is where it is a little more tricky with information versus advice. I don't tell somebody you should file an answer. The best thing for you to do is to file an answer. Those things would be advice. What I say instead is, well, you have 2 options. You can ignore it, and that's the fastest way to get evicted. You will lose automatically, or you can choose to file an answer. What do you want to do? And let them decide. And if they make an informed decision that they want to file an answer, I say, great, here's how you do that. Does that make sense? So there is a little bit of like do-si-do you have to do, because it's always, what do you want to do? It's not my decision, it's your decision. And there are consequences to filing an answer. It means you're going to court, could mean that the cost of the case goes up. And what you would get instead is a chance to have a reserved chance to participate in the process. Does that make sense? Okay. So if somebody wants to file an answer, they could use the summons, which is supposed to have a short URL for people to go to, and a QR code for people to scan with their smartphone so that they could go to this page to get help filing their answer. Does that make sense? So let's see how we can wiggle that page. Because it might be that if you're helping somebody who's facing an eviction, might be that you would help them through this process, right? That would be something that maybe you would do, hopefully, maybe. Okay, so I have to tell you that our website was upgraded to a new system over Thanksgiving. And this is the old website. But that's where the link goes. And I'm going to fix that right away. So we're not going to go to that page. I'm not going to show you that page. I'm just going to show you the new page. And I will fix that. So I apologize for that error. This is what it will go to once I fix that. And I made a note. So this explains how to file an answer. And it says if you're being sued for eviction, see our page on eviction information for tenants. So then somebody could click here. And this walks through, where are you at? So what you do depends on where you're at in the process. And we talked about receiving a notice. And it sort of explains the information that I told you, which isn't that enlightening. Hurry up and fix it if you can. And it is better if you can. It's just hard to do. It also says what do you do if you receive a summons and complaint. So you can click here, and then you can click here, and it walks you through what your options are. One of the options is to file an answer, which is in the form section. And the answer is here, or they can use this online system. Most people just want to fill out the form. So let's talk about it. So this is the form that the tenant can fill out if they want to answer the eviction case, to slow down that fast track, to not go down the bad path, to go down the path of not having an eviction happen immediately, to be able to participate in the case. With me? Questions so far? Questions on the chat? Okay. So answering a case is kind of hard. It's complicated. We don't make it easy, and I apologize for that. When you answer a case, what you have to do is take your summons and complaint, and you have to scroll to the part that says complaints. Might look like this. Like this. So they're going to get this big packet. It's not going to be tidy when they get it. It's going to be a big mess. And it might be all In my former life, I did eviction defense. I helped people in San Francisco who were facing eviction in DC. And, you know, it would come messy, it would come crumpled, there'd be pages missing, and that's just how it is. You do the best you can, right? So what you're supposed to do is read through the numbered paragraphs in your complaint. And for each numbered paragraph, so if you got the one for non-payment from Kurt Colomore's office, there are 31 numbered paragraphs. So you have to go through each one of those numbered paragraphs and put it into a box. And there's three possibilities. You either agree with everything in that numbered paragraph, you disagree with even a little part of that numbered paragraph, or you don't know. So you'd go through each one of those numbered paragraphs and add it to one of those three boxes. Admit, deny, don't know. Does that make sense? Questions about that? So you can't do that unless you got the complaint in front of you. Yeah, question. The way it works is if you admit it, then they don't have to prove it. If you don't admit it, then they have to prove it. Technically, yes. They have to. What happens at the occupancy hearing? We're sort of skipping ahead, and that's fine. No, that's fine. So we're doing this exercise. We're going to answer, which means that we will get to the occupancy hearing, just to make sure people are following the path that we're on, right? With me so far? So the question is, what happens at the occupancy hearing if I deny something? And the short answer is some of that's just stuff that they have to say for other reasons. How much of that is going to come up in the occupancy hearing? It's going to probably depend on the judge and whether the judge knows that entity. So your number 10, so I'm going to tell you a secret. There's more than one occupancy hearing scheduled at once. There's usually several in a row. So if I just heard from the same plaintiff, they just proved to me, and I'm the judge, that they own the building, I might not make them go through that exercise every single time. But you know, the big one is usually what happens at the occupancy hearing, the big question is, do you admit that you owe the money, yes or no? And if you admit that you owe the money, then you have to move. Because there's not the fact that there are problems with the unit doesn't necessarily mean you don't have to move. But if you deny that you owe the money, then the landlord's got to bring proof and show why the money's owed. And then if you've got receipts to show or something, or some sort of, here's the transfer on my phone that shows the money transferred, then there's more complication, more to talk about. Most non-payment cases do get resolved, figured out one way or the other, whether the tenant has to move or not move at the occupancy hearing. Other kinds of cases are more complicated. So did you cause a nuisance? Are you causing a nuisance? Well, that's pretty complicated because we have to have witnesses, we have to have people come in and testify. Is a judge necessarily going to do that at the occupancy hearing? I don't know. But it's harder, it's more work for them, right? Good question, thank you. Other questions about doing the answer?
I guess, what's the downfall of just saying you disagree with everything?
I, as a court employee, have to tell you, you're supposed to have a good faith basis for everything that you say in a paper that you file with the court. You have to have a basis for a reason to believe that. So once you go through that exercise of deciding whether you admit, deny, or don't know which paragraph, and you have a good faith basis for doing it, so then you can raise some affirmative defenses, things like the landlord didn't give me the notice, or they're doing something different in the paperwork than they gave me, like someone's a complaint than they did in the notice, or I complied with the notice, I fixed the problem that they said I had, or within the 3-day notice period, I presented the landlord money and the landlord refused to accept it. That can be a defense. I'm actually not a tenant. We don't have a tenant relationship. Maybe it's about non-payment violation of the lease. And so if it's violation of the lease, then I can show that I actually did comply with that lease. The person suing me is not the landlord. They're not the owner of the building. They don't have a right to bring the case. Maybe the defendant is in the armed services and they're on active duty in the military. So they're like overseas fighting the war for like the country. They shouldn't get evicted. There are some protections that apply in that context. Or maybe I gave the keys over already and we shouldn't even need to be doing this. I shouldn't be sued because I gave up the place already. Or they didn't comply with some technical rules around following this stuff. You can also ask the court to sue the landlord in a very limited context. So in an eviction case, you can say that there were repairs that weren't done. They didn't comply with the law regarding repairs. And so I actually don't owe them all that money, or I owe them no money, less or no money. And if you owe them no money, then it's conceivable that you could survive that occupancy hearing challenge. But if you're saying I owe them less money, that's not necessarily a defense to the case. Or the landlord's holding onto my stuff, or this is in retaliation. I called the building inspector because there's a public health crisis and the landlord responded by evicting me. Those are the kinds of things. Or the landlord's already evicted me. They've been coming in without giving me notice that they're coming in. Those are the kinds of things that you could sue the landlord for in the context of an eviction case. Questions about that? Okay. So if I file the answer, and by the way, you can email to file your answer. Do people know that? You can, so I could get out my phone and I could take a picture of my answer, each page, turn it into a PDF and email it to the court to file it. So one of the concerns people have when the lawsuit's going is there's only so much time I have to respond, right? It's 3 days. If the last day falls on a Saturday or Sunday or a day the court's closed, I have until the end of the next day. So it's not business or calendar, it's kind of an in-between thing. But I have to get it in before that deadline. If I don't, I could lose the case automatically, right? So if I'm worried about getting my answer in, I can email it to file it to the court, with the court. And how do I do that? Well, I can go to the homepage, utcourts.gov. I can click down here, representing yourself. And there will be a link from that answer page that walks through how to do it. But I'm just going to show you where the page is real quick because my life's too short and you don't want to watch me figure that out. So there's a page here that will be linked more readily from our current process that says, here's how you file documents via email. And there are 3 possibilities. I'm filing a protective order or stalking injunction, I'm starting a new case, or I'm filing in an existing case. So the people we're talking to are filing in an existing case. So we click here, and there's instructions. Make sure your subject line includes the case number, include contact information, attach the documents, attach them as PDF. And you can click here where it says email addresses to pull up a little table. Helps you figure out how to file. So we're in Weber County right now. I'm filing an existing case. So I would email to Weber Morgan D at utcourts.gov. I would probably just copy and paste it so I don't risk messing up the email, right? So somebody could come to you, and if they made the choice to file the answer, you could help them fill out the form. And if you're helping them and you're not telling them what to put, you're not giving them advice, you're just saying, here's the form, you're explaining the questions and answers. You could help them fill it out, and you could help them scan and get their documents filed with the court, if you want. Or you could have them call the self-help center if that's too overwhelming. Questions about that?
How does the time limit work on that? I guess, does that go up till 11:59 p.m. of that day?
That's a good question. The court tries to not have people default. And when I say default, I mean lose automatically, like in the flow chart. So losing automatically is sometimes called default in lawyer speak. Sorry, I do it sometimes. And generally the court tries not to do it. So what I've been told when I've asked this question before is that well, let's pause for a second. So if the tenant doesn't file their summons or complaint within the timeline that's required, those 3 days, at that point, they don't lose automatically. At that point, it's a race to see who gets to court first. If the landlord gets to court first, then they can ask for a default and the tenant loses. If the tenant gets to court first, they can still get their answer filed. Does that make sense? So you have 3 days. It's like a child's game. I think it's tag or something where I can run to home base and be safe. But if I don't run to home base before that time's up, then we're racing to see who's going to get there first. If they get there first, then I'm out. What I'm told happens is that the clerk will wait to see if there's anything filed before processing a default. And if nothing is on file, then they will process the default. Because we're not trying to screw people over. We want people to engage in the process as the court system. That's what the court wants. And we can't make the landlord wait forever if somebody doesn't file their paperwork. Like, that's not fair to the landlord either. The court's got to be fair to both sides, right? Does that make sense? Other questions? Okay. So the occupancy hearing will be scheduled within 10 days of you filing that answer. And what's supposed to happen at the occupancy hearing is the court's supposed to decide whether or not the tenant can stay there. And it could be that you say, they didn't make these repairs, but I do owe them the money. That would mean that you would get evicted, but your case would not be finished. Does that make sense? Okay. I think that's calendar days. So, but at the occupancy hearing, people can raise issues they want the court to hear. They can bring proof. They can tell the court what's going on. If the court thinks that everything can be wrapped up and there's no other issues, things can be totally resolved at that point. Most cases don't get resolved at that point because the landlord's got to figure out how much you owe in damages. So let's talk about that. But before we do that, let's talk about the order of restitution. So the order of restitution is the actual order from the judge to the sheriff that says this person has to get evicted now. And I'm going to show you what it looks like. Looks like this. So it says, to the defendants, within blank days, you have to move out of the premises located at this address. You don't have one in your paperwork. Move out means get all your stuff, get it out of there, give up your keys, get your stuff out. If you don't, then the sheriff will come and the sheriff will physically remove you from the property. It also, on ours, not everybody does this, but on ours, it tells them about their rights. So you have the right to get certain things back within 5 days. So you can get clothing, identification, financial documents, documents that show you're on sort of government benefits, any medical information, prescriptions, medications, any medical equipment, crutches, wheelchair, oxygen, things like that. The landlord just has to give you those back. They have to. And you have to ask for them within 5 days. If you don't ask for them, they don't have to give them. But if you ask for them, they have to give them. Okay? They can't charge rent. They can't do anything. They just have to give you that stuff. I'm telling you that because after those 5 days, they don't necessarily have to. It's more complicated. And if you want to get your stereo, your laptop, other things like that, you have to have request those within 15 days, and the landlord can charge you a reasonable storage fee for that stuff. What's a reasonable storage fee? Don't know. So there are some things you can get back right away. Clothing, medical stuff, important documents, that you can get back right away. No charge. Other stuff, they can charge you. They can charge you a reasonable storage fee. Does that make sense? If the landlord doesn't give you back your stuff, or you think the landlord's overcharging you, you can file a form with the court to ask the court to hold the landlord accountable, like why aren't you giving them their stuff back? Or let's talk about what a reasonable storage fee is. You can do that by filing a request for hearing. Here's the hard part. People think that when they file the request for hearing regarding enforcement of an order of restitution, they think that means that it stops the eviction. They think it means it can get them back into a place. That's not what it's about. It's about, is the landlord giving you back your stuff, your clothing, your medical equipment, your documents. That's what it's about. It's about what's a reasonable storage fee. Those are the kinds of things that this document's for. It's not going to stop the eviction. Does that make sense? And it's painful because they call me when they filed it and they think they're going to stop the eviction. It doesn't. It's heavy. It's heavy all of a sudden in here, isn't it? It's really heavy. Okay. So that's what the order of restitution looks like. So at this point, we've seen all the documents that could be the papers I get when I'm getting evicted. It could be a notice. We know what that looks like now. It could be a summons and complaint. We know what that looks like now. Or it could be an order of restitution. So I'm getting evicted. Well, what should I do if I'm getting evicted? Well, your options are going to depend on where you're at in the process. So if I'm getting evicted and I got a notice, try and fix the notice. I'm getting evicted and I got a summons and complaint, you can try and you can choose if you want to file an answer, or you can choose not to file an answer. And if you choose not to file the answer, that's a fast track to have the case be decided against you. And if I got the order of restitution, I still have some rights. I can get my clothes, I can get important documents, I can get my medical stuff back, and the landlord just has to give that to me. If I want other stuff back, they can charge me reasonable storage. Yes, it's the same process regardless of whether it's a residential or it's a commercial tenancy. It's complicated because businesses have to be represented by a lawyer. You can't represent your own business if you're anything other than a DBA. So if you've got a partnership, you've got a corporation, you've got an LLP, you, as an individual, even if you're the principal, you can't represent that business because only lawyers can represent people or licensed professionals. So they would have to, they could, I mean, you could try, you could do it, and sometimes the judge will accept it. But technically, if the other side wanted to say, well, that's not valid, I don't know what the court would do. Does that make sense? What other questions do you have about anything I've talked about? Do you feel more or less comfortable about talking with people about their housing problems after this? Are there things you wish I had explained in more detail? Yeah. I mean, usually, I think, between us and People's Legal Aid, there is help available for people. So, I work for the court. I can't change the laws, and I'm not supposed to comment on the way the laws are or aren't. But my job is to help people access the system. And what happens usually is when people go through the process, they tend to get more time, of course, because they're at least going to get 10 more days, right? Because if I don't file an answer, I'm going to lose automatically, and there's a fast track for eviction. If I do file an answer, there's a little more chance to engage with the process. And I can have a hearing and I can talk with the judge about what happens next. The other thing is, I forgot to mention this. After the occupancy hearing, I might have been evicted, but the landlord can still come back to court to ask for a damage judgment against me. Are those just mumbo jumbo words, or do you know what I mean when I say that? People say, go ahead. Great. Well, I'm talking about like they wouldn't wait that long. They usually wait between 2 weeks and 6 months. But so the landlord doesn't know how much the tenant owes in unlawful detainer damages money until the tenant's actually been evicted, because before then we're still accruing money. And as People's Legal Aid probably told you, whatever your daily rent is times 3 once that notice expires, right? Infuriating, perhaps. You said it. I didn't say it. So the landlord has to calculate that and tell the judge how much is owed. When they do that, they can submit an affidavit of damages to the court, and the court has to then calculate that. The tenant gets a chance to respond to that affidavit of damages and say, here's my side of the story. And you stole my cards, but there are flyers in the back for a program called My Case. And if you sign up for My Case, you will get an email notification when a document's filed in your case, so you can get a chance to know about it. Can you hold that up for me? Yeah, so people can sign up for My Case. And if they have My Case, they can get notified when documents are filed in their case. They can actually go in and log in and see what that is to see, do I agree or do I disagree with how much they're asking for? It's not that it's the date that the tenant last occupied the unit. So what was the date that they either moved out and surrendered and gave up their keys, or what was the date that the sheriff came and removed them? That would be the last date. Does that make sense? Because that's the time that the argument is the landlord can't re-rent that property, so they're losing money because no one's paying rent at that point. So they're entitled to go back to the court to ask for that from the tenant. And if I go back here, just to be clear, this does explain the different options. So if you receive an affidavit of damages or other paperwork requesting a judgment, this explains what people's options are for responding to that. So they can file paperwork saying, I disagree with it, and explaining why. And so, I have seen a case where the landlord said that they spent 3 hours cleaning an apartment and their time was worth $500 an hour. So that could be the kind of thing where a tenant might make a choice to file something saying they disagree with that, to ask the court to look more carefully about that, maybe have a hearing so they can share what proof they do or don't have. The other thing is, in that context, a landlord has a duty to mitigate, to try to lessen the amount of damages that they are owed, and they're supposed to show that as part of their request for money. So what's the landlord done to try to minimize their losses? I used to do eviction defense, and this was in California, not here. The general principles apply. You can ask for a reasonable accommodation for your landlord at any point in the process. But the court is just sort of administering a process. The landlord is supposed to engage in an interactive dialogue with the tenant around what's going on. And what does that look like? It's complicated, but somebody could send a request for a reasonable accommodation to their landlord at any point in the process if they have a disability. What the landlord does with that, I don't know. Asserting your rights under the ADA and the Fair Housing Act, the Americans with Disability Act, and the Fair Housing Act is the kind of thing that a lawyer could be really helpful for. But if somebody has so the Disability Law Center does try to take some disability cases. If somebody needs a reasonable accommodation earlier on in the process, they do take those cases once in a while. They do want those cases, I'm told. What other questions do you have? Okay, so there are cards back there for My Case. There are flyers that point people to the resources on our website. And please take some cards, because this is a powerful tool for anything beyond just eviction, but also can help with eviction. You can also email us or text us when you're with somebody. And if you're texting us when you're with somebody, it's a good bet you'll get a quick response. Thanks.